right, my presentation this morning is on responsiveness and responsibility. And this is kind of a boring topic, I must admit, so I'm going to do my best to keep it a little interesting. Outline of topics. I want to run through, tell them what you're going to tell them, and then summarize. I'm not sure I'll have time for the summary. I'm going to tell you about a few resources you need to be aware of that I'm going to refer to in the presentation. I'm going to tell you why I think this issue matters. I'm going to tell you what law I want to benchmark to, because you need to benchmark to something if you're talking to 50 different states with 50 different sets of rules, potentially. Then I want to talk about what is responsiveness, what does that word mean, and how does it apply, and what are the mechanics of it during the process. And then tell you what responsibility is, and contrast that with responsiveness and how it applies. And then I want to talk about what I think are some of the problem areas where the line between the two comes close. Okay, the resources I want to talk about. We've already talked about the Model Procurement Code, so that's what the book looks like. The next one is a publication by Missy Copeland. She's a lawyer in South Carolina that Delbert and I have known for at least 25 years. And she is the editor of a guide written by 50 different people from around the country, lawyers in every state. So there's a chapter on every state, and it runs through the law on procurement in that state from a kind of a high level. So if you have a multi-jurisdictional practice like she does, this is your first step. Like, what's the protest deadline, and what's the appeal process? Well, there's a section we added in the third edition on every state as to whether or not they adopted the model code. So that's a resource for you. I'm going to be talking about the federal acquisition regulations. I used to get teased that I would take the FAR home and read it at night, which is not true. But this is the book. Delbert, I will tell you this. There are two books. Dixon Robertson is a lawyer in my office for 12 years. He's the best procurement lawyer I know. And just a remarkable lawyer. He came to my office, knew nothing about it, drank the Kool-Aid, and is just extraordinarily talented at it. There are two books on his desk at all times. The third one, which is called The Baby FAR, it's about that thick, and it's the Federal Acquisition Regulations. And the other one is the Model Procurement Code. And he doesn't do anything on any issue until he's figured out how does the Model Code address it and how does the FAR address it, because it's so informative. And I realize we don't want the states to have the FAR, believe me. I'm not advocating that. What I'm advocating is it is a powerful tool and a powerful resource. The last book is George Washington University Law School has, to my knowledge, the only government contracts law program in the country where you can get a graduate degree in government contracts law. And this is the basic textbook on the acquisition process. I bought it with my own money. It's the best money I've ever spent on any law book. I recommend you buy it. It's just a great reference guide. You want to know what a minor informality is? It'll just give you a list of examples and cases and explain it. You want to know what this part of responsibility is? It'll go through it. It's just a great, even if your law is different, it's a great textbook. I'm sure Nancy is familiar with both of those. All right. Why does a presentation on this topic matter? Well, the applicable bucket, whether you put a question, an issue in the bucket of what I call the responsiveness bucket or the responsibility bucket, really determines how you deal with the problem. What are the mechanics of it? What can you do? What can you correct? When can you correct it? When do you make the decision? All these different pieces. So it will often decide who wins or who gets to continue to participate in the process. And the reason it's worth a presentation is because these concepts are often confused. And that's a quote from the two authors that are really legendary in the federal government contract space. And they wrote that textbook I mentioned, Nash and Sabinek. Why does it matter? The differences in mechanics. For example, whether a nonconformity is a matter of responsiveness and responsibility. What information can be used to correct that nonconformity? When does the determination as to whether a nonconformity matters or not is made? What's the level of discretion that the procurement officer has, or what level of deference do they get if there's a review of it? Can you correct the nonconformity at all, and if so, how? And each one of these is different if it's in the responsiveness bucket versus the responsibility bucket. And given how important it is and the confusion between the two, it's important to clearly understand the differences. If you actually understand the rules, the differences, and how they work clearly, you provide the government a lot more flexibility and you keep more bidders in the pot. And that's important because of competition. I think the thing I used to like about our state's acquisition process the least was the number of bidders who got thrown out that in retrospect now, with a much better understanding of how these work, we could have kept in the process. Sometimes bidders that were the highest ranked offerer that the agency selected that they wanted to do business with, and we decided on the view we had at the time of the rules, we threw them out. So, when I talk about this, I want to give you a set of benchmark that I'm going to refer to because your mileage may vary, right? Each state may have some different nuance. Your appellate court may have made a decision that you really can't change and you have to live with that doesn't meet with the benchmark. But the benchmarks I want to talk about are the Federal Acquisition Regulations and the ABA Model Procurement Code. Let me start with the second one. The Model Procurement Code in 1981 and still is a slimmed down or right-sized version of the concepts in it that were borrowed from the Federal Acquisition Regulations. And I'm going to demonstrate that to you by putting them side by side, the current rule in the FAR and the current rule in the Model Procurement Code, particularly on these two issues, and you are going to be, I'm going to put the proof on the page that they're almost identical, right? Well, since there are decades and decades of court decisions, administrative opinions, treatises, textbooks, and articles that talk about these concepts at the federal level, if you are a model code state or you have definitions that are similar, and I have found definitions that are similar in many states that I would not identify as model code states, then maybe that is relevant to you. Maybe that authority is relevant to you. And even if it's not, oftentimes just understanding the contrast, right? So if I pull out the restatement second of contracts and I find the rule and the restatement on my issue, and then I go research my court decisions in my state on the issue, and they're different, just knowing that there is a difference between what the restatement second of contract says and my state says is informative to me as a lawyer. Okay? Just like I would want to know if I'm looking at the UCC whether my state has a non-conforming, a non-uniform provision on a UCC issue. So the point here is not to teach you or to presume that I know the law in your state, but to teach you what the benchmarks say and then help you appreciate how that might inform your practice. Just as the baseline, it used to be about 25. It's the number that the research tells you over the years is differed. I base this on the ABA 50 state guide. There's the 11 postal codes. I'll get one of them wrong, so I won't read them out. But those are all identified by the authors in that state as a model procurement code state. My two favorites just happen to be Hawaii and Arkansas. I'm sorry, Hawaii, Alaska, and Kentucky, which are solid model procurement code states and have some great legal authority. Okay, I've already given you the disclaimer. Skip over that. So what is responsiveness? All right, what I really want to do is I just want to give you, what I like to do is take something that if you read the law, it can get really complicated, and I want to just boil it down to the nugget. I don't want, if you try to state one rule to rule them all in the law, you'll never get there because there's always the exceptions and the alternatives, and right, the lawyers just tend to really make it complicated. What I want you to walk away with is just what's the core idea that's going to answer 85% of the questions. That's what I want you to walk away with. So what is responsiveness? It deals with the question of whether the contractor has promised. What is a contract? Right? On the front end, it's an exchange of promises. At least that's one type of contract, right? Not one where you just start performing, but an actual, I promise to do this and you promise to do that. That's a contract. That's the core of a contract, this exchange of promises. Well, responsiveness deals with the question of whether the contractor has promised to do exactly what the government has requested. That's responsiveness. This issue came up yesterday in boot camp. I think it was Megan talking about materiality. Somebody was. It's not, did the bidder follow every requirement of the bidding instructions? Okay, so let's suppose the bidding instructions say you must submit 30 copies. And they don't submit 30 copies. That has nothing to do with whether the contractor has promised to do exactly what the government requested, which is why you would probably find the vast majority of jurisdictions would say that's a minor informality. The idea is it has nothing to do with what they've promised or how much or what they're going to do for you if they get the contract and how much you're going to pay them or what your obligations are. So I'm not going to read each one of these because I'll never get through the presentation. But what I'm going to do is I'm going to go through this and I'm going to put the model code and the Federal Acquisition Regulation language on the screen. And as you go through this, what you're going to see is the content, the core. There are slight variations in the wording. They're the same. I can't discern any material difference between the model code and the FAR. And in my state, our definitions are very close, if not identical, to the model procurement codes. And I've tried to highlight some of the key language for you as you go through. Minor informality, I'll highlight a couple of words. Matter of form rather than substance. And effect on price, that's a promise. That's a post-award performance issue. That's part of what happens during the contract. Price, quantity. Under the UCC, you cannot have a contract for the sale of goods unless you have a quantity, a firm quantity, or it's an output or requirements contract to substitute for it. You have to have a price, and you have to know what you're buying. And without those three, you do not have the essential elements of a contract under the UCC, right? These are core contract issues: price, quality, quantity, delivery, contractual conditions. And it can't have more than a negligible effect on it. Okay, we'll come back to those concepts. This is from the minor informality definition of the FAR and the model code. The model code does not have a parallel to the next one, but it's from the FAR. And I think it's interesting because you can see at the very last sentence, this is, oftentimes you define something by what it's not. Okay, so in my mind, and my state has this FAR regulation that's on the next screen. I didn't want you to read it, I want you to listen, so that's why I back up. One way you define something is by what it's not. So if the minor informality rule tells you what is immaterial, what tells you what's material? And if I give you examples of what's material and I give you examples of what is immaterial, then that gives you a pretty good idea of where the line is between materiality and immaterial. Because if it's material, it goes to responsiveness. You can't fix it. If it's immaterial, you can. So the minor informality rule tells you when something is immaterial. My state adopted this regulation from the FAR, which tells you when it is material. So if it fails to conform to the delivery schedule, it shall be rejected. By rule, that's been made material. If the bidder, for example, bids, this is the end of D, for example, bids shall be rejected. In other words, it is material, in which the bidder protects against future changes, qualifies it as being subject to price and effect at the time of delivery, limits the rights of the government under any contract clause. All right, what are those? They're all performance obligations after they get the contract. They're promises. They have to do with the contract. Okay, and the last sentence kind of ties back into the definition of a minor informality, matters of form rather than substance. And this one says, a condition goes to the substance of a bid where it affects price, quantity, quality, or delivery of the items offered. If it modifies the promise, the federal regulation says it's not a matter of form, it's a matter of substance, and therefore it's material. All right, the core concept is focus on the contract, not compliance with every jot and tittle of what the buyer who wrote the solicitation said they're going to make mandatory. Buyers will modify bidding instructions for their convenience. We will throw you out if you do not send us a complete electronic copy on a thumb drive and 10 copies, and you can't throw them out as non-responsive with that. Not under the reference law I'm looking at, because it goes to form over substance. It's not about the contract. This is a case that I found a useful quote, the Seaboard case from 1990. This is a protest decision from the federal government, and at the federal government, many of the protests are decided by the U.S. Comptroller General and have been for a couple of generations. To be responsive, a bid must represent an unequivocal offer. All right, just stop right there. Basic contract law, right? You must have an offer, it must be accepted, and then you have to have what? An exchange of promises with consideration, offer, acceptance, consideration, basic concepts from law school, right? However long ago that was. Well, here, it must represent an unequivocal offer, so the bid has to be an offer, not an offer to negotiate, not a here's my cut sheet, and we'll talk about it later, but an offer to provide what? The exact thing called for in the solicitation. And we'll come to the difference between RFP and IFP in a minute. Such that acceptance of the bid, acceptance of the offer, contract law, right? I'm going to beat that until you're sick of hearing it. Acceptance of the bid will bind the contractor in accordance with the solicitation's material terms and conditions. Boom. It's all about the contract. That's the core concept in responsiveness. That's the only thing you get out of this presentation. That's the walkaway. Okay? So, my rule of thumb, does the nonconformity change the contractual obligations of anyone, the vendor, the state, or anybody who's a party to the contract? If no, they're probably responsive. We'll talk about some exceptions. If yes, if the nonconformity does change it, they're non-responsive and you're done. Now, I have yet to find the case that gives me a good example that I could cite that said, yeah, well, it cost $100,000 less on this $10 million contract and we're going to consider that minor. I mean, I don't know about you, but the easy way to think that through for me is I can have a $300 million construction project and you can win the low bid on $10. So I have yet, if somebody finds a really good case on that, send it to me. I haven't found it at the federal level, I haven't found it in my state, and I haven't found it in kind of the treatises. If the offer is accepted without, then the second rule, and this is not the point of the presentation, so I'm not going to spend any time on it, but if anybody wants to talk about it at a round table or catch me or discuss it, I'm including it because I felt like it would be wrong not to just stick that out there for anybody who pulls out the slide deck. And that is, if the offer is accepted without modification, will a binding contract result without modification? If it won't, if you can't simply say, we accept, here's your award, and a contract is formed, then they're probably not responsive. How am I doing on time? I got 30 minutes left, is that what that means? Okay. Two rules of thumbs on exceptions. So exceptions to the contract-based rule of thumb, yes, there are. One of them is it contrary to the procurement code? So at the federal level, and this is not an issue that we like in South Carolina, and I suspect many states differ from this, but I'm going to explain the exception so you understand conceptually, and it's a good example. At the federal level, they take the position, the statute mandates that bids have to be opened in public. It is a statutory requirement of bidding. In our state, it also applies to RFPs. In the bids, the RFP is a little more nebulous. In bids, it says you shall announce the bidder's name, the price, and so much of the contents of the bid as irrelevant, which is a matter of discretion for the procurement officer. Well, if a vendor marks their entire bid confidential or trade secret, I'm sorry, you've just imposed a condition on me that prevents me from complying with the law. We cannot consider you, you're out. That's a problem. Now, we've never had a problem with people marking some. We have special statutes to deal with it. I'm not really interested in debating that rule or discussing whether it's the same in your state or not. That's not the point. The point is, the basis of it is one of the exceptions to the issue of contract, my rule of thumb, which answers 85% of the questions, is when whatever they've done violates the code or doesn't comply with the code. Some states like mine have what's called a subcontractor listing statute. And it says you must list your subcontractors on construction, and if you win the contract, you must use those subcontractors unless we excuse it and you allow a substitute. In effect, that's now part of the contractual obligations. You must use your subs, even though it's nowhere in the solicitation. Well, failure to list means we can't consider you, and the courts just say you're non-responsive. I'm not sure they ought to even use the word non-responsive in these examples. I think we ought to just say, well, you're not compliant. But we treated the courts for years, and the administrative decision makers have called it responsiveness bucket, and that's what it is. How about pre-opening conferences? At the federal level, they say failure to attend a mandatory pre-bid conference does not change your contractual obligations upon award. So you can make it mandatory all day long, but if they don't show up, you can't refuse them an award. You can't treat them as non-responsive. My state did not like that, so we promulgated a regulation and we said, we really don't think you ought to make it mandatory. There are really good reasons not to, but if you do a written determination that justifies and you get approval to make it mandatory, you can withhold, you can prevent somebody from participating. I didn't like it, by the way, but I have a client and I do what they tell me to do, right? And they really thought a lot about this and they decided they wanted to keep that door open to the possibility in some instances. But we made it a lot harder to make them mandatory. And the feds say you can't do it at all. Nancy was shaking her head, so that must still be the law in D.C. Bid bonds. Bid bonds really aren't about what you do after the award. It may be that your surety pays you after award, but it's not part of the contractual performance obligations. No bid bond, non-responsive. So, and then the last one is there are examples of issues that are treated as responsiveness that do not go to contract performance. They're not about did you offer the government what they ask for so much as the policy reason is they undermine the reasons for competitive bidding. And the only good example I could find of that is unbalanced bids. And those of you who are unfamiliar with it, let's suppose I put out a statewide bid to buy all the pencils and all the 100-page hole punches for the state. And I just award on the low combined unit price. So I say, give me the unit price of one for each, and the low price for those two is my bid. Well, if you're a smart bidder, you're going to say, listen, they're only going to buy 1,000 of the hole punches, but they're going to buy 1,000,000 pencils. So my bid price for the pencils is really high, and my price for the hole punch, which cost me a whole lot, is really low, but at the end of the day, I'm going to make a whole lot money. I'm going to make a whole lot more money. It's going to cost the state a whole lot more, but I'm a low bidder the way you told us you were going to calculate the bid price. And the courts say, if you tell them that unbalanced bidding isn't allowed and they give you an unbalanced bid, that makes them non-responsive. All right, let's talk about the mechanics of responsiveness and how it applies. Going back, what do we mean when we say mechanics? What information can be used? When must it be made? What can be corrected and how? And the level of discretion or the standard of review. So it depends on the source selection method, and this is where it gets a little complicated. And every state has a little different variation on how a low bid is kind of low bid, low bid, low bid for everybody. RFPs, there tends to be more variation in how the states manage it. So I'm going to do my best to navigate the distinction between the two. So almost universally, I've never seen anything that even suggested something otherwise. In low bids, you have to be responsive. Right? So when we do construction bids, when we do almost all bids, we want 2, and if it's construction, 3 things from the vendor, and that's it. I want a signature, I want your price, and I want a bid bond. If you give me anything else, unless it's required by statute like subcontractor listing, you're going to mess it up. You're going to create a problem for yourself. And we build $100 million stadium on low bid, we have in the past, and all we get from the vendor is price and a signature and the bid bond. All right? In best value procurements, which maybe you may call it RFP, you may call it competitive sale proposals like the model code, you may call it competitive negotiations like the FAR does, but it's where we consider factors other than price. I'm aware of 3 different variations. Starting at the bottom, what the FAR says is at the time you make the award, the proposal must be acceptable. And what it means is it has to conform to all material requirements of the solicitation at that point in time. Now, the FAR anticipates solicitation amendments after opening as part of the process, okay? So what might be conforming in all material respects at the day of opening may be different than what's conforming on the day of award. But you still have to conform to all the material requirements to be eligible for award under the FAR on the day they sign the contract. The model code says the proposal must conform to the solicitation. That's the phraseology it uses. Okay? Same basic concept. As I read the model code, and I think the proper reading of it, although not the read we used to give it, is that at the time you sign the contract, it has to conform. Right? You can evaluate one, you can look at them, you can even put them in the pool of people you're going to negotiate with if it doesn't conform on the day the solicitation is received, but they have to be conforming at the day you make the award. The way South Carolina did them for a long time, and we still do them effectively, well, yes, is the proposal must be responsive at the time it's received. Or we legislated ourselves, maybe 10 years ago, I can't remember, a little window where we could go back and all we could do is we could say, if you'll delete the language in your proposal that made it non-responsive, we can keep you in, otherwise you're out. But we couldn't evaluate you, we couldn't negotiate with you, we couldn't do anything if you weren't responsive up front. Now that was South Carolina's variation. So South Carolina has now two variations. We have something very similar to the FAR, and then we have what I've called a traditional, for lack of a better way to put it. I go through those differences because the mechanics depend on the source selection process. Right, so low bid, I'm not going to walk you through each one of these definitions, but these are the low bid rules for the FAR and the low bid rules for competitive sealed bidding, or IFBs, low bid award. And you can see conforms in all material respects to the invitation for bids. Okay? There's actually the word responsiveness, I can't find it anywhere except in the title of the regs at the federal level. There's no definition, but this is what it means. Comply in all material respects with the IFB. The model code actually defines it. Best value. So if you're looking at the model procurement code provisions on RFPs, as provided in the RFP and under regulations, discussions, which at the federal level means negotiations, discussions may be conducted with responsible offerors who submit proposals determined to be reasonably susceptible of being selected for award, so you can negotiate with them, for the purpose of clarification to assure responsiveness to the solicitation requirements. So the concept of responsiveness in the model code in RFPs is still there, but not at bid opening, right? You can conduct negotiations or discussions with them after bid opening to fix it. All right. However, at the end of the day, when you make award shall be made to the offeror whose proposal conforms to the solicitation. So mandatory, you can't make award unless they conform to the solicitation. Now that begs the question, do you have authority to amend your solicitation? And if you do, how do you do it in a way that's fair to the other vendors? And that gets really complicated and is beyond the scope of today. Happy to discuss it with anybody who wants to. But the idea is the mechanics work differently in an RFP and a bid. And then the FAR, it says the winning offeror must be technically acceptable under the RFP. That is, it must ordinarily conform in all material requirements. This is at the point of award. All right. So if you're talking about responsiveness, particularly in a bid, it's got to be determined in general solely from the face of the bid and the materials submitted with it. That's it. You can't chat about it. You can't clarify it. You can't do anything. Either they're responsive on the face of it, or they're not. And I love this. This case says, in general, this New York case comes in and says, which I just thought was a California case, perhaps one day there will come a case where the determination of whether a bid is truly responsive will require going beyond the face of the bid. That said, no such example is found in the case law. And I haven't found one either. So maybe you will. Is it the same rule for IFB and RFP? Good question. I tend to think at the end of the day, the rule is, it's a contract, right? So at the end of the day, if you get right there to the point where you're going to make the award, and you look at the face of the solicitation after you've done your negotiations, after you've done your everything, if the contract document that you're going to accept from the vendor to award on an RFP does not on its face conform with the material requirements of the solicitation, I think on the face of it, you can't make that award. Okay, so when is it determined? Well, in a low bid, we've already talked about this, it's at bid opening, right? In best value, if you have the concept of responsiveness, or if you have this rule of it must conform before you do it, then it's after negotiations, but before award. And I'm not going to go through all the citations. You get the idea. What can be corrected? Okay, well, in an IFB, it's probably nothing but minor informalities. And so this is what that treatise book I mentioned, actually it's another guy who's written a 3-volume treatise, which I highly recommend if you can get your office to buy you stuff you buy, and that's Feldman's book. The bidder generally may not correct, clarify, or change the bid based on written or verbal explanations the bidder provides after bid opening. The rule at the federal level says, listen, if there is an ambiguity, if there are more than two reasonable interpretations of the bidder's bid, then you cannot accept it. They're non-responsive and you can't fix it. Why? Because the bidder can now choose which interpretation to give you after you award, which may change their performance obligation and their price and give them an advantage in the bidding, because they may say, well, I meant that one, but they can decide after bid opening whether they want to honor the contract or whether they want to win by telling you which of the two reasonable interpretations. If there's only one reasonable interpretation, that's the one you have to apply. That's the federal rules. And I think the model code rules. Okay, the deference for the standard. There are a couple of examples, we rarely run into them in South Carolina, about judgmental issues, but as a general rule, a government's determination of whether a bid is responsive is subject to very limited deference. The courts can look at the face of that bid as well as we can, right, and decide, did you take exception, did you agree? In fact, it's gotten to the point in my state where they spend very little time even being willing to listen to experts or take testimony on it. A lot of it's done on the record as to whether or not you're responsive. However, it's not always that simple. The two classic examples that are mentioned in the Model Procurement Code, comment number 2 to the section on bidding, is that their judgmental evaluations, particularly where bid samples or product descriptions are submitted, may be used, and those there's deference to the procurement officer. An example would be, let's suppose you're buying canned mace that you wear on your belt. Well, when you pick that up, you need that mace to work immediately. There's probably some little lever that you have to swap with your thumb to unlock it so that you can depress it. Well, if that doesn't work smoothly and easily, the whole purpose of having the mace is undermined, right? I'm not sure you can draft a specification to explain that. Carpet is a good one where we look at samples to identify characteristics that you can't really write into specs. And I think that the judgment of whether or not those meet the intent of what you've said you're going to be evaluating is a place where there is some room for judgment in bid responsiveness. This is just the second paragraph is the citation on this issue of ambiguity and two interpretations we talked about a moment ago. All right, that is responsiveness in a nutshell. What is it? What's the core concept? What can you correct? When can you correct it? How do you correct it, right? So let's contrast that with responsibility, at least under the model code and the FAR. So the basic idea is completely familiar, I'm sure, to everybody in the room. It involves the question of whether the contractor can, and the or will, I'm going to put to the side for a minute, can perform as promised. So it's not the most qualified bidder, although I have found a few old court decisions back before there was a model procurement code, back before states had ever heard of the FAR, right, or anything else, but back before we all talked together, back before there was a NASPO, there are some really old court decisions that will talk about the government actually being able to use responsiveness to determine the responsibility to determine the most responsible vendor. That's not what you find in the model code of the FAR. So it's not the most qualified. It's are they capable of performing? Now that's a matter of business judgment, and there's enormous deference. I've done nothing but encourage procurement officers in all my years, throw them out as non-responsible. If in your business judgment, that's not worth the risk, throw them out. It's not who's best, it's not ranking, it's a determination on that bidder. You can determine a bidder responsible who's filed for bankruptcy. And there's cases that say that. You can determine someone, non-responsible who has a lot of discretion there. You have to be, your buyer has to be arbitrary or capricious or violate the law in doing it in order for their determination on responsibility to be thrown out. The other basic idea that the code provides is if they don't give you the information you ask for, you can throw them out for that too. You just have to give them a reasonable opportunity. All right, but the core concept I'm talking about is whether they can perform. This is where you see that language in the model code, capability in all respects, satisfactory record of performance, of integrity, qualified legally to contract. Here's the FAR, able to comply with the requirements and proposed delivery, satisfactory performance record, integrity record, qualified and eligible to receive an award under the applicable laws. Pretty consistent between the FAR and the model procurement code. The reason is pretty basic. The government shouldn't be contracting with a business that's incapable of performing the contract, and I hate to say there are too many examples where we have, and the state has suffered for it. I think I have seen less than this many determinations of non-responsibility in 25 years. In my book, that means the procurement officers don't feel confident enough to do it. They haven't been told, do it. Don't worry about the protest. We can win that protest, right? It's a matter of business judgment. You're entitled to make it. They're afraid they'll get protested. They're afraid the businesses will fight. I think we're better off determining them non-responsible and not having a contract failure than we are letting the protest tail wag the dog, my personal view. What are the mechanics of it? It's made on the basis of all information that may be submitted or available up until the time of the award. So it's got nothing to do with what the bidder submits. You can establish mandatory standards of responsibility. You can say you must demonstrate in the solicitation that you meet this minimum or we will throw you out, and the buyer can still call them up after bid opening and say, well, give me the rest of the information because I don't have enough to decide that you're responsible. That doesn't mean, and I'm not going to address it today, that doesn't mean you can take all the extra information they give you and give it to the evaluation panel to help them rank. In my mind, I haven't found case law that says that gives them a second bite at the apple to sell themselves, right? That gave them more time to prepare. That's not the point of today's conversation. But for making the determination of responsibility, which belongs to the procurement officer, you can ask for that. You can start asking for that information before you issue the solicitation. You can ask for that information while you're waiting for solicitations to be proposed, and there's cases that talk about it. You can ask for it after bid opening. And what does that do? It allows you to keep people in the competitive pool, which increases your competition, helps you get a better deal, and doesn't throw out the very vendor that may be the very best one for your state. So understanding the difference and what information you can rely on and why it's any information available versus the face of the bid helps your process be more flexible, and you help your people. Because responsibility decisions are largely a matter of judgment, they're generally given wide discretion, and that is clearly the case law. You've got to have a good reason for a court to overturn a decision of responsibility. An error in information or a failure to consider something might be a reason, but that's no longer the matter of discretion, that's doing your homework. Okay, when? Right before you post the award statement. You can make that determination of responsibility right up to the minute of award. Why? Well, what if they filed bankruptcy the day before you posted your award statement? Well, you're not responsible now, we're going to somebody else. Do you have to reevaluate? I don't know, that's not today's presentation. But it's not like bid opening, you make that decision. In my state, on a traditional RFP, you have to make that determination of responsiveness before you start negotiating, right? On an IFB, you make it at opening. Responsibility, kind of universally, you can make it up until the moment you make award. So you can fix it. You can cure it. In fact, the next topic, what can be corrected? Everything. They can fix any problem. Now, there are always exceptions, and I will come to those in a minute, but generally, they can fix anything. The exception might be special standards of responsibility, and that's really beyond today. I've given you some resources to look at. We'll talk a little bit more about them later, but those are the ones where you've set the standard. So you might say, since the injection grout we want you to use to repair the 200-year-old blocks in the Citadel building, the injection grout we've specified requires that we only get a warranty for it if you're certified by the manufacturer to apply it, and you can only be certified if you've worked with them for 3 years and you've done a 6-month evaluation process. If you don't, we need that certification. You can't correct it. If you didn't give us the information, we'll let you submit it later, but you can't go cure it. We're not going to wait for you, right? But that's really not about correcting it so much about is did they meet it on time? Different issue. So the fundamental difference, one deals with whether the contractor has promised to do exactly what the government has requested, and the other is whether they can or will perform as promised, and that's right out of that textbook I gave you. I remember when I finally found this in the textbook, and it was like, I'd done this for several years and struggled with it as a bid protest lawyer for the state. It was like a light bulb went off. I was like, wait, this just makes it so much more clear as to how this ought to work. What are some frequent problem areas in the 9.5 minutes we have left? All right, one of them that has gotten a lot of abuse in the public contract law literature, particularly at the federal level, is how often we're part of the problem in the way we draft them. And I've given you some examples earlier, right? If you don't have if your office is not within 10 miles radius, what's a better example? Give me 10 references, right? And then the references state a mandatory standard of responsibility. You must give me 10 references, and each reference must have been a contract where you did all these things for this amount of time with this much square footage for this many years. You know, you did janitorial services for a level 3 hospital that had, 4,000 square feet, that had 4 operatories, and if your reference doesn't meet that, you're out of here. Right? And now you've just really, if you don't submit it with your bid, you're out of here. The procurement officer, in a good faith effort to make the system efficient, just threw out the ability to keep people in the competitive playing field. And we've had so many bid protests on that could have been avoided. Performance obligations versus issues of responsibility. So in a solicitation for Medicaid transportation, the solicitation requires the offerer to submit their motor pool maintenance plan, and the vendor doesn't submit it. Well, if the solicitation doesn't make the maintenance plan a performance obligation, then it's not a matter of responsiveness. It might be something you're going to evaluate them down for. It might be something that if you're using it only to determine responsibility, you let them submit later. But if they're not contractually obligated to perform, to maintain their motor fleet in accordance with the plan that you evaluated, if it's not a contractual obligation, it doesn't make them responsive. If you do require them to operate in accordance with it, and that's part of the promise that you're evaluating, then it is an issue of responsiveness, and you can't correct it unless you're in an RFP and you have the ability to negotiate and that kind of thing. But it goes to a material requirement, and their failure to give it would be a nonconformance if it's a contractual obligation. And you can see how the way the agency drafted it or the central purchasing office drafted it decides the issue. Compare this one. I love this one. At all times, this would be performance. At all times during the term of the contract, contractors shall employ no less than 10 full-time, properly licensed, registered nurses. That's a performance obligation. You got to have 10 nurses on staff working all the time throughout the term of the contract. All right? Contrast that with you have a special standard of responsibility. You have a whole section or RFP called qualifications, so they understand the context of it. And what you tell them is you'll have no less than 10 licensed nurses on staff. Offeror's proposal shall include resumes for its employees that satisfy this requirement. Well, now you've restricted competition because the qualified nurse, they could lose one right before they submit their bid, and boom, they're done. Right? They don't meet the qualification. And number 2, it didn't achieve anything because they could fire 7 of them the minute they get the contract, because there was no performance requirement. So the way we drafted it and applied it shot ourselves in the foot and gained us nothing. It actually, hurt us. Whereas if you dealt with it as a performance obligation, now I get to use my business judgment as the procurement officer, given the market conditions at the time, whether it's reasonable for them to go find 10 nurses when you have a nursing crunch, right, on short notice when they have none. And I can say, well, do you have any? I'm doing my determination of responsibility. You've said this can do this. You didn't identify anybody. So how do you plan to meet that? Do you have a subcontract? Are you going to pay triple salaries to recruit them? I need some sense of confidence in my business judgment under the responsibility determination that you can meet that performance requirement. And if you can't, we're not going to take a chance on awarding the contract to you. Now you've got a firm contractual commitment, and you've given somebody judgment to make a decision on whether they can meet it, instead of throwing out competition and putting in a requirement that got you nothing. That's the power of the difference between the 2 buckets. There are problem areas where it's just, I couldn't give you the answer. And what I have found is that the courts will often say, it depends on the facts and how the government intended to use it. So I'm not going to give you any really great examples, but we talked about manufacturer approval. Sometimes you're getting, you'll get somebody to submit a product, and sometimes you actually want that product for a reason, and sometimes you want it to test it in advance. These are the kind of issues that I would go research to get the case law on, right? They don't exactly meet the they're not easily resolved by the rules of thumb. How about that? And that's why I always go to try to find a case. And that textbook that I mentioned, the last book on the 4 up front, it has multiple cases that address every one of them. They'll be like, well, in this case, they said it was responsiveness for this reason. In this case, they said it wasn't. And here's the reasons. Points to remember. For almost any procurement issue, you'll have a better understanding once you know the applicable federal rule. That's why Dixon keeps a copy of the FAR on his desk, because it's a resource. It's like pulling out the restatement second on government contracts. And the model code was drawn from it, and it reflects, it's not like the federal acquisition regulations just poof came out of thin air, right? People have been doing procurement since the Civil War, okay, or the Revolutionary War. I mean, if you read the history of government contracting, there's a whole history book on it, which I have not read, Delbert. I'd take some real teasing at the office for it. But there has been, and so the FAR didn't just come out of thin air. It's kind of like a textbook on it. I think we've covered all these. There you go. Questions? We've got 3 minutes. Comments? This didn't help at all. Yes, ma'am.
Here we go.
So, Counselor, question for you. You talked about issues of responsibility prior to award, but do those issues linger beyond award responsibility?
One more time. Say it one more time just to make sure I got
Do
it.
issues of responsibility linger beyond award?
Yes. Yes. The law doesn't mandate it clearly, so I don't know that I would put it strictly under the heading of responsibility. But if you're going to do a change order, you really ought to be evaluating if it's particularly significant, right, whether or not they have the capability to do it. That ought to be a part of your analysis. How many people have, well, no point in hands. In my office, the lawyers, all of us, just really don't like dealing with and have tried to simplify the issue of assignments and novations. Well, have you thought, well, I really need to determine the responsibility of this vendor before I agree to it, okay? But generally, the concept of responsibility as mandated by the statute ends at the point of award. Well, at the point that the award goes final and you sign the contract.
We've
Any
got
other
another
questions?
question. Could a host of minor informalities going to form, not substance, raise responsiveness concerns, and that the proposal suggests future performance issues, i.e. inability to follow directions, attention to details, or meet the state's needs? It's a great question.
No, I got it. I think it would have to be an extraordinary bid or proposal to do that. And like I said, in a bid, it's very easy to become non-responsive, right? That's why I want a price and I want a signature. What I would say is if it's an RFP, I would just evaluate it because they're going to get scored so badly you're not going to have to worry about fighting the fight of a bright line test.
And would you recommend Ken Adams' Manual of Style for Contract Drafting?
Is that the one, Justin, that you recommended that I found out about last event? I can't remember the name of it. Dustin introduced me to a manual on contract style drafting, which we will circulate if you'll help me remember, Megan. That yes has some really great stuff on particularly difficult questions. Oh, like my favorite, including but not limited to. And the court decisions and the statutory rules of interpretation are just tortured. And he has some great advice in that book on how to do it.
Excellent. So that was Ken Adams' Manual of Style for Contract Drafting, if you guys missed it. We got time for one more question.
We recently had that responsiveness issue on references, and I'm curious to see if you would have interpreted it the same way. So I'll give you like a little hypothetical. You have to mail out voter guides, you have to provide references for past performance, and in the references, the bidding instructions state you have to, on each of the references, what your quantity was in those past jobs that you've done and the price. But we don't leave you any blocks to actually write that in on our bidder instructions because that would have been a step too far. One of the vendors doesn't write the actual quantities they delivered in the past or the price in one of the references, but they get awarded the contract. The protestant says, hey, they didn't provide the quantity and the price on those past references. Contracting officer says, well, I reviewed it and I felt comfortable that they had, sufficiently performed in the past. We determined it to be non-responsive. Curious your thoughts as to whether, because that was really, failing to follow the bidding instructions, but it was also in a, past performance reference. If you would have judged it the same way, I guess.
No, I would have said they are responsive, and I would have allowed them to provide me the information if I, as the procurement officer, judged that I needed it to determine them responsible. And if it were an RFP, I would not allow them to provide that information and then give it to the evaluators to use in evaluating them, because I would feel like that gave them a second bite at the apple. And then if there were additional facts, if the requirement met the standard for what's called a special standard of responsibility, which means it must be specific, objective, and mandatory. Like, you must have a license to be a nurse. And they didn't meet that, they would be thrown out. But typically, I try to read references not that way, because typically a special standard of responsibility is very clear and it has to be identified as such. That would be my ruling.
Thank you.
Where I judge for the day.
Thank you.
All right, thank you.